Good afternoon. This is U.S. Immigration Attorney Sharifa Tharpe. I am live to take your questions, and I'm also here to give you a good topic today. So, I'm going to talk about that situation where your spouse refuses to apply for your green card. Some of you who are here may be thinking, which spouse would ever refuse to do that? Believe it or not, guess what? That does happen. Happy holidays, BJ. It's so nice to see you. I hope you all enjoyed your holidays, and then the new year is coming up. So I'm excited for what's to come next year, especially in regards to the firm. Happy holidays, Jay. And the fact that we are helping so many people to change their lives. It's so fulfilling, and I'm looking forward to a great year with my current clients as well as new clients who are looking forward to um, you know taking their lives into a new direction. So I'm wishing you all the best as well as we go into the new year. And this is one of the reasons why I'm talking about this topic, because when you're in a situation where your spouse is refusing to apply for your green card, you feel stuck. And going into a new year, I'm pretty sure it's a new year, you want change, you want progress, and feeling stuck is the last thing that you want to do, or you want it's the last way you want to start the new year. And so there's one way that I'm going to talk about that can fix this problem. Now, for those of you who you may not be in that situation, but you want to make sure that you're wiser as you build a relationship. Maybe you're in a relationship with a U.S. citizen or legal permanent resident. One very important part of this is when you're entering the marriage and you're looking forward to getting your permanent residence through that spouse, it's not a one man show. You and your spouse, to make sure that this is a successful green card process, you have to make sure that you are both committed. Your US citizen or legal permanent resident spouse must be committed to the process just as much as you are. And as a matter of fact, I would say that that's the single most important aspect of this. It's the single most important ingredient to make for a good application, good successful application process. Is it really shines through when the both of the individuals in the relationship, in the marriage, are fully committed to getting to the end and getting the spouse their permanent residence. Oftentimes, for example, I will see this, and sometimes even in consultations when I talk to couples to determine whether they qualify to get my representation. This is one of the things I look out for because I can tell that the couple will be successful. But when I see sometimes if the spouse doesn't show up, especially the citizen spouse doesn't show up to the consultation, or they don't show up to client meetings, that's a bad sign. And so, if you're starting to see that in your current relationship or marriage right now, then you need to be aware and you need to understand where you stand with this individual, with your spouse or your fiance, because it can open up a can of worms instead of making for a good, successful process going forward. So that's something that I just want to warn you about is when you're in a relationship or you're in a marriage and you both are looking forward to a future together, make sure that you talk to your significant other about their commitment to the process. Another thing is, and I see this especially with American born and raised citizens, when they sometimes there's a misconception that, okay, they're in a relationship with the immigrant and they just think, okay, they're going to go ahead, get married, and they're going to get the papers. And they don't realize how much it takes to get to the end of the process. And that creates tension in the marriage. So, you have to prepare if you're an immigrant, or if you are even a US born, you've never had any experience with the immigration process. You should prepare yourselves or prepare your significant other for how much it's going to take, how much commitment it's going to take to get through this process, because the commitment is going to be the single most important determining factor in how successful your process will be. So now let's go back to the topic at hand, which is your spouse refuses to apply for your green card. Where I see this is where the immigrant gets married to the U.S. citizen or resident spouse, and then they're just happy with the way things are. They find that they have more power in the marriage because now want the immigrant spouse, they don't have status, they can't work, so they have to stay in the house, and they have to take on all the burdens and responsibilities in the household. Or because they don't have their status, they constantly need the US citizen or legal permanent resident spouse to help them, so there's a certain power that the US citizen or legal permanent resident spouse has over the immigrant spouse, and they get comfortable with that. They like that feeling, and so they don't want to move forward with the green card for the immigrant spouse. So that's one situation that I see. Another situation is they move forward with the process, and the U.S. citizen or legal permanent resident spouse, they stop the process. They sabotage the process. They sneak and go ahead and cancel the process on the immigrant spouse without the immigrant spouse knowing. And of course, the immigrant spouse has to learn the hard way that they have been sabotaged, and sometimes this leads to accusations of wrongdoing by the immigration of fraud, for example, and sometimes a denial and or a letter stating that they have to leave the country within 33 days of the denial notice. In this case, though, if you have been mistreated or subjected to the extreme cruelty by the U.S. citizen or legal permanent resident spouse, which most times it is, because obviously this is a problem, obviously it's cruel for a spouse to turn around and do that to their immigrant spouse. And so if that has happened, usually this is indicative of that, then you could go ahead and switch the process to apply on your own, or apply from scratch on your own to get your own work permit, your own travel document, and your own permanent residence, 10-year permanent residence in the United States. And this will not involve your spouse at all. So your spouse will not be included. They will not be involved in the process at all. As a matter of fact, you are, as an applicant, as a VAWA applicant, because this will be through what's called VAWA, you are protected under the law. Your process is extremely confidential, and no information will be disclosed. In fact, they're so strict about disclosing any information that they only communicate with me. The VAWA unit only communicates with me as the attorney by email. And this is, of course, email that's only available to attorneys representing their clients. Otherwise, you have to do it by snail mail, which can create a world of pain and problems for those who are not represented. Um, and I do appreciate that, because, we do everything we can as the attorney in the situation to protect our clients, to make sure we maintain that confidentiality, and to make sure that no one but our clients are involved in the process. And it's reassuring to know that there's that additional security that's available for our clients. So even if somehow the client leaks this or discloses this to somebody and it gets back to the spouse, they cannot call and ask for any information about the process, because nothing will be disclosed by phone, and only by mail. And even then, they only communicate with the attorney on record by email or mail, and only with the actual applicant by mail. We personally, with us and on the law firm, we make sure that all correspondence comes to us, comes to the office, and we take it on behalf of our clients to ensure that nothing goes anywhere else. But it is possible to apply on your own. And yes, even if you're still with the spouse, the degree of harm that you may be facing and even the threats that you may be facing is different for my clients. I would say secure your safety first. So if you're in a situation where you fear for your safety, don't worry about your immigration. That can come afterwards, but make sure you secure yourself first. Be safe first, and then we can work with you. In cases where our clients are, they want to go ahead and move forward with applying and they're not necessarily concerned about an immediate threat, we make sure that everything is confidential and then we go ahead and we prepare the case safely on behalf of our clients, and we submit it even if that client is still residing with a spouse. So, it is possible to fix this situation. That's what I want you to take away here. And now I say your spouse refuses to apply for the green card and they're mistreating you at the same time. You can apply on your own to get your work permit, your travel document, and your green card. The process takes about 2 to 2.5 years, but you do get your work permit. It's a 2-year work permit about halfway through. So 6 months, at the 6 months after filing to 12 months after filing, you'll be able to have a work permit so that you're able to get on your feet, have identification, get your social security number, and even be able to travel outside of the United States if necessary. And whether that's advisable, it comes down to what's going on with my clients in particular. But it is possible to fix your situation, even if you're out of status, and even if you have crossed the border without permission, you can apply for this form of relief. So, if your spouse refuses to apply for your green card, then that usually is indicating to me that there is a serious problem, because I don't know any spouse that would care for you, that would want the best for you, that would not do anything to move forward in your immigration process to make sure that you have equal status in the United States, that you have everything you need to thrive and live in the United States without fear. All right. So now I'm going to go ahead and answer questions. So your questions can be anything that's immigration related. It does not need to be necessarily related to the topic that I'm talking about. So go ahead and start putting those questions in the comments. I'm on YouTube. I'm on Instagram. Go ahead, put your questions in the comments. I already see questions, so bear with me as I scroll through to answer those questions. How long does it take for a U.S. resident file for their spouse in Jamaica? So you're looking at about 18 to 24 months. Um, do you know how long a waiver would take to come from Jamaica to proceed with to apply for a green card? So if usually it depends on what the situation is, but usually you will get information about whether you qualify for a waiver when you attend the interview. You usually cannot apply for the waiver until you get to the interview at the embassy, and then they tell you whether you're inadmissible and you are eligible for the waiver. After you have applied for the waiver, unfortunately, we're seeing anywhere from 6 months to 2 years for the processing of these types of waivers right now. So they are backlogged, but they're working to reduce that. So that may change at any point. How do I apply for a Mexican passport? So you'll have to consult with the department in Mexico to determine how to apply for that. As a teacher on J1, I currently married. I'm not able to apply for a green card until waiver is back okay, so this is the I-601A waiver. So with the I-601A waiver, The way that it works is you have to first submit that petition. Once it's approved, this is called the I-130 petition. Once it's approved, then it's moved to the National Visa Center, and then you prepare that I-601A waiver. Let the National Visa Center know that you will be applying for this waiver, and then your case sort of put on in hold until the decision on the waiver comes back. All being well, it has to be prepared well. Keep in mind that the waiver has its own legal requirements. So you have to be very careful about this. This is not just filling out a form and saying, "Hi, can you forgive me for the overstay or for crossing the border without permission?" This requires extensive documentary evidence, and sometimes even we do get other professionals involved, like medical professionals or therapists, to talk about maybe the emotional impact on the U.S. citizen or legal permanent resident spouse, parent that's involved in this, because the waiver requires you to show that your U.S. citizen or legal permanent resident spouse or parent will experience extreme hardship if you don't get the permanent residence, if you don't get the opportunity to attend the interview for permanent residence. And so, as you can imagine, you can't just say this, you have to prove it with documentary evidence. So it does take some work. Get in touch with me. I can talk about it, see if you qualify, and we can get started right away. And then there are also other considerations. Is it worth it to just wait for your spouse to become a U.S. citizen? What I usually say here is, I mean, the considerations are going to differ based on your particular circumstances. But what I would say here is if your U.S. citizen spouse is, say, they are eligible right now to apply for citizenship, they could be a citizen within a matter of months. Right now, I'm seeing 2 to 3 months for my clients from filing to them becoming citizens. I've had clients that are now being sworn in on the spot. So it can happen very quickly, and that may be worth it to wait. But you do have some other, like, green card holder spouses who they just got their permanent residence, and it's not till another 5 years till they become a U.S. citizen. So in that case, where your spouse is going to have a long time until they become a U.S. citizen, then the I-601A is going to be worth it here. Um, Great questions. Keep those questions coming. I'm here to answer. So put those questions in the comments. Hi there. I'm just scrolling through to look for questions. Do you take on clients in another state? Absolutely. I represent clients in all 50 states and around the globe. I travel the country representing my clients. So I'm not limited by any borders or state lines. All right. So my wife has a 19-year-old son that is not my child. When we got married, my wife's son was already 18. I'm a US citizen. Can I still petition for him to come to America? So in this case, you would not qualify as a step parent. You would not qualify to sponsor your wife's son. You're in order to be able to sponsor your wife's son, you would have had to get married before your wife's son turned 18. So in this case, you would not be able to file. Your wife, if she's a permanent resident, would have to file for the son. And right now, if the son is under, so you said 19, they're still in a good position because children of permanent residents are in, right now, they're on the same processing time as if a US citizen sponsored the child. So it's a good time to file, get in touch. we can get started right away to file those documentation and evidence. So go ahead, call. On YouTube, you'll see the phone number going across the screen. And here on Instagram, there's a whole link that leads to a page on Linktree with everything you need to get in touch to schedule your own appointment, to be able to speak with me and to do a legal evaluation. When petitioning for my 5-year-old child through VAWA, how long will it take? So now, you can't petition. I'm thinking your 5-year-old was included in your VAWA application. If your 5-year-old was included, then once your VAWA is approved, it's at that point that your child, if they're outside of the United States, they're going to then be able to get the VAWA status to come into the United States, and be able to stay here on deferred action. If they are already here, then they are going to, as soon as you get approved, they will also get the VAWA. As long as that 5-year-old has been included on your VAWA application, they will be able to stay here and even adjust status along with you to get permanent residence. But this happens at the point you're approved, doesn't happen before. My aunt submit a petition from 2008 for my mom and I, and to date, no response. So that's going to depend on the processing times. Right now, so what's happening here is your aunt filed for her sibling. And when that happens, it means that it's about a 14-year to 22-year process, depending on which country you're in. Mexico is on the over 20 years. In the Caribbean, it's about 14 years. So that may be the reason that is happening. So 14 years from, you'd have to add the 14 to the 8. And then if you're not hearing anything, did you get a receipt notice? Have you had correspondence with the National Visa Center? You may want to just check on the status there. Okay, so if you do take on clients in another state, how do I get in contact with you? So there's a link in the profile, and my phone number is on every single video on my page. So there are many ways to get in touch. So go to the link in the profile on Instagram, click on the link. You'll see buttons to schedule your own appointment. You'll see buttons to go to the website. Go use one of those to be able to schedule an appointment. When you call the number, you're going to get in touch with a scheduling coordinator who can answer your questions and then schedule the consultation. That's how you'll be able to speak with me directly. Okay, so how can we make contact with you, as this is over 11 years? Go ahead, call the number, and you can go to the link in the profile and you'll see everything you need to get in touch with me, and then schedule that appointment. You can do it on your own, or if you need help, then the scheduling coordinators are available at the phone number, and that goes for YouTube as well. If you will see my contact information below, and then also on the About page on YouTube, the link is also available there. What if someone entered the US illegally? So, it depends, but some individuals who entered the country illegally, they also have access to VAWA in this case, since we're talking about VAWA. But there are other ways, and then also the I-601A waiver that I just mentioned previously. That's the main way that you'd be able to fix your status if you're doing it through a spouse. However, if that spouse is mistreating you, or the relative is mistreating you, like a parent or a citizen child who's 21 and up, then you can apply for VAWA and your permanent residence, even if you enter the country without permission. If I'm in Jamaica, but my fiance is a US citizen, how long will it take to file? So right now, we're seeing 18 to 24 months. He's in New York. Great. We can definitely go ahead and assist you. Hi there, Shervon. Nice to see you. We can definitely go ahead and assist you. We have gotten approvals in New York. If you want to make sure that you want to make sure if you're adjusting status, if you're in the United States, you're adjusting status. You have to be married to do the adjustment of status. If you're doing the fiance visa and one person is outside of the country, you're looking at 18 to 24 months. If you're in the country, married, you're doing adjustment of status, you're looking at about I've seen as short as 5 months and as long as a little over a year. My aunt did a petition for my mom and I in 2008. It's over 11 years. What is it? We need to get some information on the status of the application. She lives in Chicago. So if it's 11 years, it's definitely still not past that time because if it's 11 years, it's 14 years to process. But you want to go ahead and use the receipt notice to check on the status of the case. So contact the USCIS, make sure that the petition is still in process, see if it has been approved. It's far overdue if it hasn't been approved. And just make sure that everything is going well. Because if the NVC hasn't gotten in touch with you to start processing it, then something may have fallen by the wayside. You're welcome. All right. Great questions. Keep putting those questions in the comments because I'm here to answer your questions. So put those questions in the comments. I'm both on YouTube and I'm on Instagram. So just put your questions in the comments and I will answer. So my sisters filed for my mom, but she was denied because of a fight she had in the 80s. Can we refile for her if that file is cleared? So no. The keep in mind that's a complex situation. Anytime you're dealing with issues like this, inadmissibilities, um, you know, inadmissibilities, past criminal records, very complex. You need to get in touch so I can fully evaluate what's going on and determine whether it makes sense to refile. But it may, if she was inadmissible because of a fight in the 80s, then it means that the crime was probably severe enough that she has been rendered inadmissible. And sometimes there are waivers available. But to qualify for the waiver, so if this is a criminal type inadmissibility, then you could apply for a waiver based on extreme hardship by a U.S. citizen or legal permanent resident spouse, parent, or child. Since this was in the 80s, it's been more than 15 years. She may also be able to show her rehabilitation without showing hardships on the U.S. citizen or legal permanent resident relatives. So as you can see, I have to evaluate the facts to determine whether she qualifies for a waiver. And then in addition to that, has she been deported? Does she have a deportation record? One thing to note here is that no matter how old the crime is, you still do have to disclose it, even if it was expunged or cleared. It's been 8 months since filing for VAWA with prima facie received. How long more will it take to get approval? So you could be looking at, so it's taking about 2 years, 2.5 years to get an approval for the VAWA, and then maybe another 6 months to get to the interview for permanent residence. So the great thing about VAWA is that you're able to get your work permit and your travel document while you wait. The work permit is a 2 year work permit, and so it allows you to gain some stability while you wait for that decision. And so the work permit also comes with a social security number, so it gives you everything you need to sort of, get things going, get make some progress in your own life in the United States before that final decision comes. All right, so that's going to be it for me today. Thanks so much for your time. I appreciate it. I am going to be back tomorrow at around noon. So look out for me, my topics, and I would love to hear your questions as well. I hope as we approach the holiday weekend again that you have something fun planned and that you are getting ready to hit the ground running in 2023. I'm certainly here for it to help you to meet your goals, especially in regards to immigration in 2023. So hit the ground running by first scheduling that consultation with me. We can fully evaluate what's going on with you and then move forward with a solution. Have a good one. Bye bye.